summarize what findings I think that we can make from this evidence, which is one, that at least as of 2012, Grandonico and Lincoln Realty had knowledge through its agents and representatives, basically Catherine Grandonico and Nancy, that there were in fact more than 4 unrelateds living in certain of their units. I think we can find that they encouraged this practice and that it was done knowingly on the part of Grandonico and Lincoln. I think that when the fire happened, I would find that Grandonico intentionally sought to delay further inspection of the premises to avoid revealing facts that would show that they were in violation of the foreign related bylaw. I think there were essentially that Grandonico sought to obstruct further inspections. At the same time that was happening, Grandonico was communicating with its tenants, urging them to hide any evidence that there were more than 4 unrelated people living in the apartment, including hiding beds and not speaking with town officials, inspection officials. I think that you know, those facts are fairly found based on the evidence. We don't have any evidence from Grandonico that was requested, as I said earlier, I find this very disturbing. It's troubling, and it really does appear to me that this landlord sort of act in a self-serving way when their tenants' safety was at stake, and avoiding further fire inspections or putting them off because they were worried about being found out on this violation of the zoning bylaw. So I would find those facts. Obviously, I don't do this by myself. There are 2 other members of this board, each of whom have a vote in this matter, but that's how I see this case. Without where I come down on this, and again without second guessing what the building commissioner did, which I think was entirely appropriate in following his procedures, is that we have evidence that the violations went back to certainly the spring of 2012, but if one wanted to pick a date, certainly by the date of the fire, I don't think there was a question in anyone's mind what was going on at these units. And I think that raises an issue of the appropriateness of a penalty for the period between that time at September 13th and when the first ticket was issued on December, I believe, 17th. The bylaw in section Article 11 provides that, so let me find the page, provides that any violation of provisions of this bylaw, the conditions of a permit granted under this bylaw, or that any decisions rendered by the Zoning Board of Appeals or Planning Board under this bylaw shall be liable to a fine of not more than $100 for each violation. Each day such violation continues shall be deemed a separate offense. And I will distinguish between that language, which is the first paragraph in section 11.45, from the procedures under General Laws, Chapter 40, Section 21D, which is the procedure through which the building commissioner issued the tickets for the violation. That procedure under General Laws, Chapter 40, Section 21, was added by warrant article in, looks like 1988. So the first paragraph pre-existed. This is an additional remedy that was added in 1988. By town meeting. So the first paragraph that I read exists independently of the procedures of the non-criminal disposition. And I think that under Chapter 40, Section 14, we assume the powers of the building commissioner in this appeal, and that I think we can find that a fine under Section 11.545 is appropriate for these violations, which I see as, again, intentional, knowing, wanton, egregious, and frankly reckless. And I think we wouldn't really be upholding our duty if we didn't impose an additional penalty in particular since it appears that this landlord has been able to extract premium rents by knowingly violating the bylaw and renting to more than 4 tenants. And if they're not penalized sufficiently, then essentially they'll have gotten paid for violating the law. So that's, those are my thoughts. I know I just said a lot, but and there's also the request that we need to address, the request to withdraw, but I open it up for discussion. And I also want to, before the hour gets too late, hear if there's anyone in the public who wishes to speak regarding this matter. But I want to hear from the other members of the board. Ms. Greenbaum.
I agree with you in terms of all of the findings, but I'm still confused regarding our role here. If the town of Amherst and the lawyer for the property owner have already reached an agreement, which I assume has been signed, do we have powers granted by anybody that we can overturn an agreement that the town has already negotiated and signed?
I don't know what the terms of the agreement are. My understanding.
And neither do I.
Well, maybe we should hear from the building
I don't know whether
commissioner.
that's a public document or not.
My understanding is that those fines were issued for a period starting on October 19. I'm sorry, December 17.
December 17th.
Until some date in the future.
Sure.
So what the period that's left unresolved is the period before December 17. And what makes this, I think, case unique is that, again, the building commissioner acted appropriately, but what's happened is facts have come to light subsequently that show that the violation went way back in time.
I understand that,
so
but what power do we have if an agreement has already been negotiated? That's where I'm confused.
I don't know if town council has any thoughts on this.
Well, it's an interesting question. The agreement, resolves, I understand, the non-criminal disposition fines. Is that correct?
The agreement resolves the violation that was cited and puts an end to the assessment of the fine accruing at a daily rate.
And those were non-criminal for the tickets, the
tickets.
ticketing process, right?
That's right.
Well, there is, even though it's non-criminal, here's what I'll just tell you what I'm, pardon the pregnant pause, but what I'm puzzling over here is sort of an issue of double jeopardy, which is a criminal concept, you know, that somebody can't be tried twice for the same violation. The interesting issue here is that the zoning bylaw, one section are criminal fines. The ones that come out of the Zoning Act are criminal fines, and you have to go through a criminal proceeding in district court to collect them. The whole point of the ticketing of the non-criminal procedure is to streamline it, much like a parking ticket. Nearly self-enforcing, not quite, but if people are willing to pay it, more or less self-implementing. What has been resolved then is the non-criminal side, and that's why I'm hesitating here, because double jeopardy is a criminal concept. But I mean, I do wonder if there's a due process issue here. What was levied at the outset were non-criminal fines. They've been resolved. I frankly never had it raised to me. Can a zoning board then, at this stage, levy criminal fines, which I assume is what you'd be talking about, because I would agree with the point that's just been made. If the non-criminal fines have been levied and an agreement's been reached, now maybe, I don't know, maybe the agreement's not final, maybe the board can look into the nature of that agreement, but you see what I'm saying? They're apples and oranges here a little bit, so we need to be focused. Are we talking about the non-criminal fines, which have been levied to a certain level, or for the first time levying criminal fines? Anyway, those are the issues that this raises that we'd have to talk through.
Mr. Eric?
So I see us as having come here because the appellant appealed from an order of the building commissioner. and that it was our job to decide that appeal. I have not conceived of it, and I don't yet, and I still don't, that that as a result of the appellant having appealed to us, that we now stand in the position of the building commissioner as though we're looking at this freshly to make whatever determinations we might make based on the facts that are before us. So that's one important legal point that the chair stated, that this appeal puts us in the position of the building commissioner, and that doesn't strike me as being natural. Now I just want to say that I completely share the factual findings. When Mr. Farber was up here at the original hearing, I wasn't soft with you about the basis of your claim that we should overturn the building commissioner's order based on because there wasn't sufficient information about the knowledge of the landlord of the fact of there being more than 4 tenants. I haven't, and I really thought, Mr. Bard, that this was an excess of caution to say that we really needed a great deal more evidence in order to reach that conclusion. So I really share your conclusions, but I just find us in a different posture. I really think that we're here to, we came here to decide the appropriateness of the building commissioner's order, that the building commission, that issue doesn't even exist before us anymore because it's been resolved. So I certainly am not prepared to go beyond that and make a series of findings and then issue and state and find and impose fines, or pretend that we're the building commissioner and impose fines and criminal fines. You know, the appellant and his party, they didn't come here with any understanding that that the civil appeal, if you will, was putting before us the question of criminal penalties. So I take a more restrained view as to what we should do here, but I don't take a more restrained view as to the facts.
I just want to make one quick response, and then maybe we should hear from Mr. Farber. Again, I apologize for the delay in hearing from you. It's Chapter 48, Section 14, Powers of Boards of Appeals, provides that the board can hear appeals in accordance with Section 8 of Chapter 48, and hear applications for special permits, petitions for variances. And says, in exercising the powers granted by this section, a Board of Appeals may, in conformity with the provisions of this chapter, make orders or decisions, reverse or affirm in whole or in part, or modify any order or decision, and to that end shall have all the powers of the officer from whom the appeal is taken, and may issue or direct the issuance of a permit. So what I'm proposing is that we would modify the building commissioner's order to impose the fines on the date of the cease and desist, which he could have done at that time. He, I think, was following a process.
What were the last 3 words of that section?
Read that
you just
again,
read? Was it
please.
of
Read
a
that
permit?
statement.
The whole thing?
No, just the last 3 words. It was of a permit?
And to that end shall have all the powers of the officer from whom the appeal is taken, and may issue or direct the issuance of a permit.
Okay, so it's not that. So you're saying it's all the powers of the office from which the appeal is taken.
That's my understanding.
Right, and that's, I actually was busily trying to call it up on my iPhone, but that's the way we think of it is that the board stands in the shoes of the building official when they hear an appeal like this.
And so just to complete this thought, and then we should hear from Mr. Farber. And again, I'm not in any way criticizing what the building commissioner did. This appeal was taken from the issuance of the cease and desist order, and I think the building commissioner properly could have, was within his rights, and we would then have those powers in this appeal to issue fines on the day of the cease and desist order. He chose not to do that. He was restrained, and he worked with the appellant to try to correct the situation, which again, I do not second guess that, but these facts have come to light, again, showing how I think, egregious these facts are, and that it, I wonder if he wouldn't have started the fine sooner, if he had known some of this information. At the same time, I also want to make clear that my reading of Section 11 does not require knowledge, the level of knowledge certainly, or any knowledge of a violation for the building commissioner to issue a ticket for a violation or to issue a cease and desist order. I believe that under Article 11, the building commissioner has a discretion to pursue the actions that he believes will best serve the town and enforce the zoning bylaw. I'm just raising now, in this specific situation, given these facts, would some additional penalty be appropriate? I think the answer is yes. I can't do it on my own. If there's not agreement, then something else will happen. But I just want to explain my position. Maybe we should hear from Mr. Farber. Thank you.
Thank you. Obviously, I'm Attorney Lawrence Farber. I represent the appellants in this matter, Grand Donegal Property LLC. I can appreciate on a certain level before I start what appears to be the anger and frustration of the chair. I believe the chair is, unfortunately in this instance, acting beyond the scope of what he has the authority to do in this. And I want to correct some of the factual issues that, although I have withdrawn my appeal because they were raised by the chair, I would like to address some of the ones which I am concerned with being on the record. And I say this with all due respect. It's not meant in any way as criticism. I just think, first, I want to stress that this was an appeal, and you have to read the language of what was being appealed. The appeal was whether it was appropriate to fine the individual who was being cited. Nothing else was appealed. That, what is going on now, is way beyond the scope of what was requested to be appealed, and I don't think you have that authority. And that's why when I did an analysis as to filing the request to withdraw the appeal, we no longer contested whether or not in this specific instance, whether or not the building inspector had the authority to bring the fines against my clients. We withdrew that. We worked out a resolution. We have paid, my client has actually paid the fines at this point, a substantial amount. We are not talking about $100. We are talking about a substantial amount. I will leave it for the town to discuss the amounts, but it was a substantial amount and a substantial resolution of the situation. So I do want to stress that what was appealed, and that's what this board has the authority to look at, it has been resolved and is beyond what is being raised today, is beyond the scope of that appeal. And for that reason, I don't think you do have the authority to what you're suggesting. If I had appealed something else, it might have been. But in this instance, all that it was, his question is, was the right person being fined? We have agreed, we have withdrawn our appeal because we recognize the building commissioner. In this instance, based on these facts, and we still dispute some of the representations that were made by the students, but I'm not going to go into that. That's not the part that I want to address with this August board. What I want to address with this August board is a few of the concerns that I think is raising some of your level of frustration, understandably, with it. You have several times stated that there was no smoke detectors. I think the building commissioner will tell you that is not true. There was a smoke detector down in the basement. There was not a CO detector. What the fire department and the building inspector's office requested is that they felt that there should be more smoke detectors down there than was there. There was one. They wanted 2 additional smoke detectors placed in the basements to increase the electrical panels servicing those smoke detectors. All of that was done by my clients as quickly as it humanly could be possible by hiring the independent contractors. And that was done within 2 or 3 weeks, not even 10 days, I think it was done, that they got the independent contractors in there. That is not something a landlord has the authority or expertise to be able to do. So it was not the dangerous situation that was being there. The CO2 detector was, there's a heating element in a different part of the basement that they felt which does work on gas or propane. I don't remember which one it is, and that was the concern with the CO, and they have been installed also. So it is not the same kind of thing where we were allowing people to live without smoke detectors. In fact, I have a email that I'd like to tell you from the person who actually caused the fire. The fire was caused, and I respectfully submit that there was a finding of the fire. They didn't find the exact cause, but they found it was caused on a bed from an electrical device being left, turns out it was a curling iron, on the bed that caused the bed to catch fire. So it was nothing that was inherently wrong with any of the electrical systems or the layout or something else relating to the conditions of the premises. It was a tenant negligence that caused the situation. Non-intentional, we are not suggesting in any way it was that. Katie Fishman was the individual who was living in the basement of number 28 at the time that the fire occurred, and she wrote on October 2nd, Dear Lincoln Realty, just for your information, I work with the AFD, that's Amherst Fire Department, and some of them know me personally. None of the fire detectors were tampered with. In fact, the first thing I did when I moved into the apartment was check the fire detectors to make sure they all worked. Also, I would like you to let you know that when we previously had fire extinguishers in the basement before the fire, I noticed there was no labels on the extinguishers. That indicates, it goes on other issues that I don't think is relevant here, but I wanted to point out that she checked the smoke detectors when she moved in to make sure there was, and there wasn't even, there was in the basement. So I want to stress that it wasn't a situation. Now I want to address the second part of this, which is some of the concern about the alleged delay. And this brings up the question that was raised by Mr. Airgood in respect to what is the rights. And I respectfully submit that, and this has been litigated in housing court, the lease language that gives us permission to go into a premises outside of an emergency only gives us the right to request. Even though the lease language says we're entitled to go in on 24 hours notice, the law states that that just gives us the right to request permission to go in 24 hours. Without that, we cannot. Tenants are the ones who have rights of possession. Once you rent a premises, you no longer have a right of possession. The Fourth Amendment makes all people secure in their homes. The tenants are the ones who are it's their homes. Unless there is a compelling exigency that enables you to enter the premises, you have to get their permission. So some of those delays were caused by the tenants themselves, some of whom had illegal individuals in there. We are not suggesting it wasn't. We would submit, by the way, that some of those representations are not accurate, but that is not what I was prepared to do today because I withdrew the appeal. We admitted that there has been a problem. We admitted that there was sufficient evidence for my clients to be fined and for the building commissioner to find that there was a violation, and we have owned up to it, and we have paid a substantial fine in respect to this. I submit that the hearing one side without the other, when there is no issue before you, I can understand how it would get you frustrated and angry hearing one side's without hearing the other side's version of what happened. And
I asked you for your side, and you haven't provided anything.
And that's because we withdrew our appeal because we worked out and faced up to the responsibility of paying the fine and resolving the matter and reaching an agreement with the building inspector on how to go forward to ensure this never happens again. And that is what we have done. We have agreed to add a provision in bold letters, single size of a whole page, on the front of or attached to every lease, which the tenants will have to sign, informing them that there cannot be more than 4 unrelated people in the premises, and the town has a right to fine $100 a day if there is such a violation. That is one of the provisions and one of the agreements that we reached with the building inspector to ensure this will not happen again. There is other provisions relating to how to ensure that the basements are configured in a way that will be conducive to ensuring that these things do not happen in a way again. So I do not want to make it seem as if we did not take this seriously and recognize that there was clearly a problem. And as it went on, we recognized, and as we investigated, that's why we withdrew our appeal. So I want to stress that I believe that what was before this board to hear could be, in this instance, withdrawn. I want to point one other thing out as to that legal issue, if I can. The reason why appeals need an approval when you are dealing with special permits before this board is because if they could withdraw it unilaterally, there is the requirement that if you have a special permit and it is denied, you're not allowed to make a reapplication for a special permit for a period of 2 years. Is my memory is 2-year period. That's part of the reason, is to make sure that someone doesn't get it right up to the last minute before they notice they're going to lose, and then they withdraw it, and now they say I can reapply 30 days from here. That is very different than an appeal of the actions of the building commissioner, in which we were questioning whether or not he was charging the right person. We recognize he was. At this point, that stands. I don't know what other authority you would have in that respect, given that we agree. He had the authority to do what he did. And we have actually paid the fine in respect to that. So again, I understand that on the surface this looked bad. Last thing I will say that it's kind of tangential, but I think you would find it instructive. I have represented the last time to you, and I will represent to you again, that many of these representations that happened were done by Nancy, the employee, who went beyond her authority, is our belief. She is retiring. That is also part of what is going to change now as a result of it, because once they were there and in there, I think the landlord's communications to them becomes more difficult. Do we force someone who's already living there out? Do we create an untenable situation of what to do with a person who we recognize may have gotten in there illegally, but now what do we do about it? I think that creates a different communications than allowing them in the first place and encouraging them to have moved in the first place, which is, I think, where we disagree on the facts. We don't disagree when someone was in there that it created a more difficult situation for a landlord to decide, how do I deal now with the fact that there is these people in there? The amount of rent that is charged is the amount of rent. It doesn't matter whether there's 4 people in there, 5 people, 10 people, 100 people. The amount of rent they're going to charge is the exact same. It doesn't get increased with more people in there. With the units that have reduced, the 2 units that did reduce, upon my initial letters, we have given them an agreement that we will only charge them 4/5 of the rent in this specific instance because of the misunderstanding that existed.
Well, let me ask you a question.
But that has nothing to do with this board. I'm telling you that solely because I want you to understand that we are not the ogres that you seem to have gleaned from the information that was placed before you.
Well, thank you very much. And I did have a question. And so you mentioned Nancy, and she was an employee of Lincoln Realty.
Yes, there's no question she's their agent and their bounds.
So she knew that Lincoln she was renting to more than 4 for some of these units.
It is clear that she should have realized. Whether she actually realized or should have realized, we didn't even go into. So, but I would suspect that a reasonable inference could be drawn that she did.
Okay, now what about Ms. Grandonico? There's an email that says that she showed an apartment to a young woman and that there were 3 beds in the basement. Did she know?
And if you remember that exact email that you read, she said these are, and we would submit as to what she actually said, but it was close. She said, this is really not a bedroom, this is a study. Now, the fact that the Students then took that to mean that that means we can have it be a bedroom. Comes up to a question of whether, of what was meant and understood and what was actually said in that instance, but that's not a case that's before you at this point.
But the email said that Catherine showed the apartment, and there were 3 beds in the basement, 3 in the basement, 3 upstairs.
And that is what, and this is the difficulty, and I understand that it creates, how do I say this? And it's, again, not meaning to insult in any or criticize. Once tenants take possession, they have the rights of possession, and landlord can enter without their permission. While the semester is going on very often, it creates a difficulty of knowing whether they are changing the rules and violating. When the landlord comes in, she only comes in at the time they're showing, at the very near the end of the tenancy, and at that point, there was beds in the basement. Again, it's already an existing situation. She didn't put them down there. She didn't say put 3 people in there. She's showing the apartment to prospective new tenants, and there happens to be that there. And she says to them, it's technically not a bedroom. This is a study. That's what we have a permit for. There was a building permit taken out in 1998 in which they were given permission to create the basements into studies. That's what we have authority to have. It's not like they turn these basements into living spaces without receiving a building permit. They're not bedrooms, and they're not supposed to be. That creates a very difficult, and I understand, and that's the reason why we decided to withdraw the appeal of, could a reasonable inference been drawn that they knew or should have known in this instance? Yeah, that's why we decided it was no longer a question of whether the building inspector had the authority in this instance to do so. But it does create a very difficult and technical and long and drawn out, quote-unquote, trial, and I don't mean trial, but hearing, that would be held to make that determination as to who knew what, when, and how. And we didn't feel it was serving a purpose when we have resolved the issue and owned up to it to continue proceeding on that basis before this body.
Yeah, and I appreciate that, and then I'll open up to questions. I appreciate that, that you've entered into the settlement, but I am deeply troubled by the evidence that I think shows that both Nancy and Catherine knowingly rented to more than 4. And then twice, the documents show that Ms. Grandonico denied to town officials that there were more than 4, that she knew anything about it. That's deeply troubling to me, and I'm not sure where to go with that, counsel. I really am not, but it bothers me, and it bothers me because at the same time that was happening, there were these dangerous conditions where, with the kids living in the basement, and it really rubs me the wrong way. Ms. Greenbaum?
I just wanted a clarification on the status of the basement. You said that 4 people are allowed to live in there. There are 3 bedrooms. I understood from one of the communications that space is not habitable space in the basement. Are there people living in the basement now? What was your agreement about the basement?
We did not address it. It is not a building inspector, nor was it anything relating to his authorities. So that issue has not been addressed one way or the other at this time. The authority of the building commissioner in this instance as a zoning officer, which is the only thing that is before this board or this board has the authority on. And again, we have to respect the jurisdictional limits that this board has. Is not before it and has not been addressed. The issue that was raised, claiming that the basements are not habitable, is over ceiling heights only. There is nothing relating to unsafe conditions.
Not
in
egress?
There. What?
Not an issue to egress?
No, there's 2 egresses. There's 2 egresses, there's sufficient light, there's sufficient air exchange, there's all those requirements that meet. The sole issue is that with the drop ceilings, the height is 6'8" instead of 7 feet. But if you removed it, it would be 6'11 and a half, so it would be technically And the fire department was the ones who told us, we don't want you to remove the drop ceilings. It creates a level of additional, they are fire-rated ceilings. Therefore, that was part of the reason why the fire never went any further, was because it was fire-rated and contained it. That's the sole concern in the basements. These are not unsafe basements. These are not situations which are a inherent hazard to people. I want to stress that. For all the faults you may find, and obviously every person is allowed to have their own opinion, and I'm not going to change that, matter how hard I try, your opinion will be your opinion. But if you ask the building commissioner, et cetera, no one has alleged that they create unsafe apartments or that they do not take a serious and responsible steps towards addressing conditions in their premises. They are some of the best maintained premises around, and if I can be so bold, as good as yours, as the properties that I know that you have rented. So that is not the concern with this. And the reason why I want it is because we are not trying to get away with creating unsafe conditions where people are put in a risk of being harmed.
Mr. Airgood?
So I have a couple of questions for Mr. Farber, but may I ask the building commissioner to, Mr. Farber has described the agreement that he's made with you, and I won't summarize it anyway, but I'd ask you, do you agree with it entirely, with his description of the agreement he's reached with you? And he's also made a number of statements about facts that would be your findings, just most recently about the safety. Do you agree with his statements, or do you?
Yes, Mr. Farber pointed out a couple of the conditions or highlights of the agreement. It's a 10-point agreement. There are a number of things that are being improved in the buildings and improved in their lease agreements and practices. So yes, I agree with the in part description that Mr. Farber gave to the board. I would also agree that from a building code perspective, the basements are in compliance. The ceiling height issue is a sanitary code deficiency that is enforced and being enforced by the health department. We have in our codes differing ceiling heights in habitable spaces. So the conflict would need to be resolved through a request of a variance with the Board of Health, and our agreement also outlines that happen within a time frame, and if successful, then we would move forward into modifications in the basement that are acceptable to myself and the health and fire officials in an effort to reduce the possibility of the basement being used for what we have found in these recent inspections.
So then from your perspective, both in relation to the four unrelated limitation and building code issues, you are satisfied with the status of, you're satisfied with the situation with this property?
I am. The agreement, it gained us quite a bit for the safety of this property, and also brought some of these issues, forced the property owner to deal with these issues through their lease agreements and notification, which I, question was happening before, certainly given the evidence here. So I think there's substantial improvement moving into the next lease term for this property.
Thank you. Now, a couple questions for you, Mr. Farber.
I'm here at your disposal.
Thank you very much. So the provision in this statement that's going to be in the lease, that the town has a right to fine $100 a day in the event of more than 4 tenants. Fine whom, does it say?
Well, again, we have reserved, in this instance, we have agreed that we have withdrawn our appeal and have agreed that the building inspector had the right to fine the owners. In future, the question would still turn, in my opinion, on A, whether the landlord knew, and B, what steps the landlord took once they did have a knowledge that there was an illegal situation. That is not the situation that happened here, and that's part of the reason why we have agreed to withdraw our appeal and suffer the consequences of withdrawing that appeal. But in the future, it would, every case, unfortunately, turns on the individual facts in it. If the landlord learns that there's an illegal situation, I believe that what we have agreed in this is that the landlord is going to have to take legal action against the violators in order for them not to be liable to the
So the
town.
tenants are meant to understand that there could be a financial penalty for them if there are more than 4 unrelateds, and what you're saying, there could be situations in which that financial penalty would fall on the landlord.
That is correct.
So would you be willing to let us, to give a copy of that statement, that, do we have that as part of the, as
My
part of your settlement,
reluctance-
or could you give that to Mr. Bagg?
All right. Mr. Bagg, I believe, has actually seen it. I do not have a problem in general. Here's my problem, if I might. I do believe anything that's tendered to the town is to some degree a discoverable document as a public document under Freedom of Information Act request. Our main concern, I believe, was for both my client and for the building inspector, not necessarily to be hampered by whatever he agreed in this to the next case that may come forward. So from that point of view, it was felt, and to be honest, not to have in the press necessarily misunderstanding why and how we reached the agreement we did in this case. I have no problems with, obviously, the Zoning Board of Appeals seeing it, but I would not feel, I would encourage it not to be made part of the public record for those reasons that I just stated, which is I do not feel it would serve a useful purpose for the town to have this necessarily, because I do believe every case is unique, and how you're going to approach next case
So
may
if
be
we,
different.
if we accept it under those circumstances, it's okay with you?
I believe
all right?
that the town has a right to see it.
Okay, Mr. Bagg, you accept it? You'll accept it?
Yep, if
Okay.
you want to
So
request that document.
the last thing I'd like to, since we're talking about that provision in the lease, is it, just for help, I appreciate what your information about the way housing courts interpret the right of possession. Is it entirely a Fourth Amendment right? Is it,
It's based on the Fourth Amendment. It's also based on contract and case law over the years that have indicated that there is a provision that basically 186 Section 14 of the general laws of Massachusetts says that a tenant is entitled to quiet enjoyment of their premises. If that quiet enjoyment is violated, the tenant is entitled to 3 times a month's rent or actual damages plus attorney's fees, whichever is greater. That has been interpreted in a number of cases as saying if a landlord enters without permission, that is a violation of their quiet enjoyment. Therefore, in a lease provision, to ask that a landlord automatically require that the tenant give up that right, I believe would be found to be illegal, especially by this housing court, but I believe it actually violates the Constitution because it's asking them to give up their Fourth Amendment rights without reasonable basis for doing so. Emergencies, towns already have the right to enter an emergency. They, again, exigent circumstances constitutes valid grounds to void a Fourth Amendment right. Just like if you're chasing a criminal who has committed a crime and they run into a house, if you're in the midst of chasing them, you have a right to enter that house and get them because it's exigent circumstances. On the other hand, if they are in that house and you know they're there, you got to get a search warrant. You can still enter, but you got to get a search warrant. This body has the right to apply to courts for search warrants, or the building inspector, I should say, has that right. They just have to prove probable cause if the tenants aren't granting it. I don't see how a landlord has a right to ask a tenant to give that up without knowledge. I'll point to and I apologize, there's a little afield from what is before this body at this time, but if you have a subsidized tenancy under a Section 8 or some form of a project-based subsidy. In there, they have absolute rights to inspect once a year. Even then, you have to give pre-notice, and if they object, there are certain rights that they have to object and not allow you in. So I point that out, that even in federal law, they are granted those kind of rights. It's not an automatic that you can get them to waive it.
Mr. Bagg?
Just two points that were raised, I believe, by Mr. Farber, which I think would be potentially a question for Mr. Bard, the town council, about the scope and jurisdiction of this board has been mentioned a few times. And I'm wondering if Mr. Bard could say a couple words about that. The facts of this case have broadened from the initial appeal, and so I would, on behalf of the board, I'd be asking for Mr. Bard to speak to that for a moment. And then the other item is on the request to withdraw. I think it is a request to withdraw. I don't think it's an as of right to just simply withdraw a case. So I'll let Mr. Bard respond to the first.
Before Mr. Bard responds, as to the request, because the request in this instance is to a narrow issue that was being appealed, I think it's de facto. I don't think it's automatic. I think it becomes, what are you then deciding? You're deciding that the appeal should be upheld. I mean, the rights of the commissioner be upheld. We've already agreed to that. I don't see how that changes in this instance. This is not a special permit or a request for the town to take certain action to begin with. It was solely, did he have the right or did he not have the right to do what he did in this instance? And I think that's a different scenario than if there was a different application before you.
Mr. Bard?
Well, the first question really leads to the second, and when the questions were asked earlier that went pretty broadly, let me say, I addressed them, but I have to say, in the back of my mind, I was thinking the same thing that Attorney Farber was, and that is that the appeal was a narrow appeal. An appellant who comes before a board doesn't expose themselves to wide open jurisdiction, if you will. They are raising a specific question. But actually, as Jeff Bagg just said, it got wider as it went along. So the initial appeal was a very specific, really, question of law. Did the building commissioner, did the town have the ability to levy a fine against the landlord? We answered as a proposition of law, yes, that ability is there. Attorney Farber came back and said, well, you have to show that we knew. And that's what opened the doors, was the inquiry as to what did the landlord know and when did they know it. And that's how we got really into this, much broader inquiry, set of facts, and so forth. I think in a sense what Attorney Farber is saying is it's been closed back down now, but it's a little bit, the barn door's been open, the facts are out there, the facts are of concern. But fundamentally, the issue before the board is simply a question of, can the town levy a fine against the landlord? I think we all agree that legally the question is yes, and I think now factually we all agree that the landlord knew enough. We certainly, I should say on the town side, we, particularly looking at the three of you, from the comments I've heard, all feel convinced that yes, the landlord clearly knew. The applicants, by choosing to settle, if you will, with the building commissioner, as we know, it's not an admission of guilt kind of thing. But
Actually, in this instance, there is no non-admission of guilt. There has been an acknowledgement. To be quite honest, we initially said we'd like to give an administrative fee that was specifically rejected by the building commissioner, saying, no, it's a fine that we're going to agree to. And I think by accepting that we were fined, that my client was fined, I think there was an acceptance as to that in this instance, we believe that there was authority to fine.
All right, thank you for the clarification. So what's happened here is we started with a narrow question. It got appropriately, in my opinion, broadened to get to the factual question of what the property owner and landlord knew. And I will say it's been narrowed back again in terms now of specifically, and this is in a sense sort of wrapping it up, if you will, specifically, what action can the board take at this point? I think it has been considerably reined in, and I mean, the board will decide in what direction you want to go, but there's been an acknowledgement of a violation on the specific issue that was raised on appeal. And so I think findings of fact, as the chair was doing, are certainly appropriate, but where it can go beyond that is in my view, fairly limited.
Well, I would just on the legal issue under Article 11, I think I said it earlier, I'll say it again. I think the building commissioner has discretion to fine an owner with or without knowledge, constructive or actual or otherwise. I think that under my reading of Article 11, doesn't say that there's a precondition of knowledge, and that he's, as a matter of policy, is able to enforce the bylaw against the people who can remedy the violation. And I think that will always include the owner. And that's my reading of the bylaw. The other members of the board may have a different reading. I just think in this case, there are, in addition, there are all these other facts, some of which came to light maybe even after the settlement was reached. And they troubled me. If it's, as I hear town council and the determination of the panel that we don't want to go any further, and again, I don't question anything that the building commissioner did. I think he acted appropriately, and he has my respect. But I was very troubled by these facts, and I want to raise the issue. So if we, however this ends up happening, that's my legal position on Article 11. You know my position on these facts. And whether or not we accept the withdrawal or we go ahead and issue an opinion, I will really, I think, want to hear from.
I have a question.
Do you have, Mr. Eric?
Well,
I think he had his hand up first.
Okay.
So I'm quite pleased with the building commissioner's testimony as to his sense of the importance of the resolution that was reached. Sounds like it was a pretty far-reaching, completely satisfactory to him solution to the to all the building code and zoning issues that are raised by the landlord here with these facts that we found, which have some sharp edge to them. And I'm not going to make I find that it's unnecessary to have an opinion about what Article 11, how far it allows me to go, because I'm not going to go beyond supporting the withdrawal of this appeal.
I'm thinking in terms of the logical conclusions here.
Can you speak up a little bit?
Oh, sorry. I'm thinking in terms of the logical processes. What happens if, then what? We have a choice of approving the withdrawal or denying the withdrawal. And suppose we don't have unanimous vote to approve the withdrawal. What are the consequences of that, other than the fact that obviously we can be taken to court? But in terms of actions by members of this body or of the town, other than going to court, what would it mean to not approve withdrawal of an appeal about something that has already been signed and agreed and fines paid to the town? What is our role here? I mean, I think that the question is probably moot, that the action has been taken, an agreement has been made and signed. If we don't have a unanimous vote, what does that mean logically and substantially?
Can I just address that procedural question? I would, in my opinion, and obviously what you're getting at is any decision to take an affirmative step here requires a unanimous vote of the
Right.
three-member board. On the question of whether or not to accept a withdrawal, does the regulation say it has to be unanimous? Oh, it does. All right, I was going to say it'd be a simple majority, but the regulation says unanimous. Interesting. Okay. never mind.
What does it mean if we aren't unanimous?
If you're not unanimous, it means you have to push on, I guess.
Well, the chair has proposed that we make findings that go beyond the scope of this particular appeal, and that we make findings and we decide on fines and enforcement mechanisms, and in order to do that, that would require unanimous approval, and I won't
Yes.
be part of it.
And if I, to jump in, not necessarily to cut off Mr. Beal, but what I heard was Mr. Beal finding facts. I think his initial run at this
To go
was
beyond that.
finding facts, which is not beyond the scope of this
He has to
case.
go beyond. He wanted to go beyond the facts.
And then Mr. Beal proceeded to propose going beyond the finding of facts and the withdrawal. So I think there is an ability to distinguish where Mr. Beal might stand on this, whether or not the board can reach a unanimous on a vote to withdraw. I think Mr. Beal ran through appropriately the facts of this case that didn't get covered very well at the first hearing. That was the findings of facts that Mr. Beal did initially. Then Mr. Beal proposed some additional steps. So the question I think goes back to Mr. Beal as to where do you stand on the additional steps, realizing that the board needs to vote unanimously to withdraw this or proceed in some other direction.
Well, I hear a lack of support for the idea of any additional remedy.
Well, I don't know. I don't,
Well,
I don't know what it means.
support from Mr. Eric.
Oh, okay. I mean, I don't know what
And,
it means.
But I think that given the investment that the town has made, this board, the various people who have given evidence, I think we should decide this issue. This, as town
Decide
council
what?
said, there's a legal issue.
What is
under
the
Article
issue?
11 of who can have liability for a violation of bylaws. Can a landlord, under, I guess, with or without knowledge, be fined for a violation of a bylaw at their premises?
But
And-
they've already agreed that the landlord, the bylaws
I
said.
want to take the agreement off the table. I don't think imagine the agreement hadn't happened, because I'm
The
not, I don't
bylaw
think we should
says
use
the
that.
the property
Listen,
owner.
let me finish, please.
Oh,
I don't
okay.
think we should use the agreement as evidence of liability. I don't think that's proper. But I think what the legal issue has been raised. It's before us. There's now a request to withdraw this. But I think given the investment into consideration of this matter, I think we should, I would not be in favor of granting withdrawal. I would propose that we interpret Article 11 and decide what it means. And I think what it means is that the building commissioner can fine owners for violations of bylaws at the owner's property. It's that simple in my mind as far as that determination.
I apologize, but if I can just say, I don't think what you're requesting is really before you. What is before you is, in this instance, did the building commissioner have the right to fine? That, I think you have the right to decide if you don't want to dismiss this appeal. I don't think what is before you is what does the meaning of Section 11 mean in all instances. And that's not my fight at the moment, but I just respectfully state, I think that the appeal was, did he have the authority in this case to fine, was he fining the right person? If you make the determination, yes, I think that's the end of it. It's slightly different, again, it's a narrow appeal of what is before you.
Yeah, I'm looking at the, well, where's the letter of appeal? Do you have that, Mr. Farber, in front of you?
I have it.
Let's see, specifically, my clients wish to appeal the portion, this is a letter from council dated October 31st. My clients wish to appeal the portion of your order suggesting that they may be fined for a violation of the zoning bylaw, section 12.152, relating to more than 4 unrelated occupants living in a single dwelling unit for the units that are listed. I do see that as a, maybe it's a mixed question of, as you may think of it as a mixed question of law and fact, but I see it as simply a determination of law under Article 11. And I think that the answer would be in the affirmative, that the building commissioner does have that authority. And I don't know how the other members of the panel feel about this. And I'll look to Mr. Aragood.
Well, the town council advised us before the first hearing that in order to that the building commissioner's order is supportable only if we find that the landlord had knowledge.
Right.
I'm not prepared, based on the discussions that we've had here, the deliberations, to disagree with that view. It may be that sometime in the future, we should look closely at Article 11. There are quite good reasons to think extending this beyond this particular case in other circumstances in the town under its circumstances, that it might be appropriate and good to have a broader view of Article 11, but I'm not prepared to decide that tonight.
And also, our decisions are not precedent-setting. Each one is judged independently on its merits. And I don't know where you want to go with this. I don't know how we can legally go more than. The decision has been made. It's signed and sealed. I don't think that we as a board have any power to undo a signed decision between the town and some.
You have to speak up
Sorry,
louder.
I don't think that we have the power, from what I've been hearing tonight, to go beyond a signed and sealed agreement. That the landlord admitted culpability and he's paid the fine. I think that's the end of it. That's how I would.
I believe that if we were in a position to construe Article 11 to permit the building commissioner to levy fines whether or not there were knowledge, then that would be relevant to this particular case. It would have made it much easier. We wouldn't have had any trouble at all. But we don't need it. It's not been raised. It's not, we don't need it. It's contrary to the advice that we've gotten from town council. And the basis of the entire resolution is an agreement that there is that knowledge, that therefore doesn't require us to have the broader interpretation of Article 11. I mean, I think that this is like go back into our own deliberations and be thinking about this later, but not now.
Mr. Chair? Unless there are people from the audience who have questions to ask, I'd like to make a motion.
Well, thank you for the reminder. I did mean to hear from any members of the public who wish to speak, so let's hold on to that thought. And
Could I just ask, just before we leave this, it was fairly significant thought that seems a little bit incomplete. I'm just curious if there's potentially another action, which is to act on the appeal. You know, the applicant has requested withdrawal of the appeal, but I'm curious, and this is an open-ended question because I'm not sure whether the board could appropriately deny the appeal instead of accepting the withdrawal. I mean,
I would be in favor of affirming the decision of the building commissioner.
and that would be the same idea.
I would be satisfied to leave it at that.
I mean, and that would be a question to confirm with town council, whereas we have been subject to this appeal, and the applicant is now asking that it be withdrawn rather than decided. And I'm hearing Mr. Beal I think I'm hearing Mr. Beal say we'd like to decide this appeal. Whether it's the narrow scope that Mr. Farber suggests, even that seems to be the question in my mind, is whether the board can actually decide on the appeal rather than accepting the request to withdraw.
Well, let me be practical. In this instance, it wouldn't make a difference because I don't think. I mean, the request has been made to withdraw. There's been a settlement that acknowledges violations, paid a fine. So it seems to me harmless to go ahead and take that action. It's just affirming, in a sense, what's already happened. I mean, it's an interesting question. Can you reject a request to withdraw? I think you can to withdraw because there's no automatic right to withdraw. So I believe you can. And I think in this instance, there'd be no consequence to doing that since it would, in a sense, affirm what has happened.
Thank you. So let's hear from anyone from the public who wishes to speak. Anybody? Okay. Mr. Aragood, how would you like to proceed?
Well, I move to accept the withdrawal by the appellant of the appeal based on the full and complete resolution of the matter that led to this proceeding.
So, Ms. Greenbaum?
Second. I was going to make the same motion, so I will second.
I'm not going to block consensus. I think I made my views on this perfectly clear, and Those are on the record. And any future appeals that raise this issue, I think those appellants would be on fair notice of at least my thinking on this matter. So there's a motion to accept the withdrawal. There's a second. Are there any comments from the building commissioner, town council, Mr. Bagg? All right, all in favor? Thank you.